Hi there. First, I want to thank FMC for once again putting on a policy day with some great programming. And I want to welcome you all. And I hear we have a very good web audience today, so I'll try and talk to you. I don't even know where the cameras are. Hi, web audience. I'm very excited to be the first panel here today. I haven't actually been involved in ACTA a lot, while in the negotiations. So I'm going to be just like you, learning from the panelists here today. And we are really lucky to have some very distinguished panelists here to discuss ACTA, which stands for the Anti-Counterfeiting Trade Agreement. So our panelists are, and I'm going to start with Steve because he's closest to me. Steve is the Senior Counsel for Policy and International Affairs at the U.S. Copyright Office. He litigated the U.S.-China intellectual property rights dispute before the WTO, the World Trade Organization. He's a leader on the intellectual property chapters of the U.S. Free Trade Agreements, and he's presently negotiating ACTA. He is also heavily involved in both domestic legislation and litigation. And then next to Steve, we have Eric Schwartz, and he's been a copyright lawyer for over 20 years, representing artists, labels, music publishers, as well as filmmakers, studios, authors, and publishers. He has also been a senior policy advisor and acting general counsel of the U.S. Copyright Office, where he negotiated worked on over 20 multilateral and bilateral agreements. And next to Eric, we have Malini Aisola, and she is a senior research associate at Knowledge Ecology International, which is a nonprofit with offices in DC and Geneva. She focuses on access to knowledge and access to medicine issues, and she works on consumer rights. And next to her, we have Michael Petricone, and he's the head of government affairs for the Consumer Electronics Association. He represents an industry that depends heavily on intellectual property and also on fair use, and he has a keen interest in the outcome of the ACTA process. And then finally, last but not least, is Rich Bengloff, and he joined A2IM as its president in January 2007. Now, for those of you who don't know what A2IM is, it is a nonprofit trade organization that's fighting for and protecting the rights of the independent music label community in the areas of advocacy, commerce, and member services. Rich represents the independent music label community on the boards of Sound Exchange and the Alliance of Artists and Recording Companies, and he's spent much of his career in the entertainment and music industries. During the past 20 years, Rich has worked at both music labels and music distributors, at both independent and major music label companies, as well as at WNYC. So, a little bit about our format here. You guys, can you turn off your phone so we get rid of interference? And so it doesn't ring during the panel. So a little bit about our format. First, I'm going to ask Steve from the Copyright Office to give us some background. And then I'm going to move on to the panelists to first discuss the procedure, because there's been a lot of interest and press regarding the procedure of the ACTA negotiations, and then we're going to move on to the substance, and then we will proceed to our questions, and I have questions, and panelists have questions, and I hope that you all in the audience and in the web audience have questions too. So Steve, starting with you, can you first provide just some background for us? Why is the agreement needed, and what's going to be the desired result? What does the government hope this agreement will do?
Sure. Thanks very much, Anne. Thanks to the New America Foundation and to the Future of Music Coalition for inviting me here this morning. I'm both flattered and happy to be here. I should begin by disclaiming that my remarks this morning are mine alone. Have not been cleared, and so should not be taken as the position of the U.S. Copyright Office or any other part of the U.S. government. That said, let me jump into the question. The ACT is needed because, quite candidly, we're in the midst of a worldwide epidemic of copyright piracy. And so I'm clear, I'm not just talking about teenagers downloading songs, though that's a serious problem in the aggregate. I'm talking about commercial enterprises engaged in massive for-profit piracy. I'm talking about organized crime syndicates, and there's every reason to believe, in some places, terrorist organizations funding themselves, at least in part, through copyright piracy. What challenges are faced globally in terms of copyright enforcement? Well, a few examples from the U.S. government's recent Special 301 report, I think, are illustrative. In one Latin American country, the government flatly refuses to enforce criminal copyright laws. In a Southeast Asian country and in many other places, court cases result in minuscule judgments, with the result that pirates essentially pay a small fine and go right back to work. In an Eastern European country, the police, if they walk by a store advertising pirated goods for sale, they can't do anything. They have no authority without a formal complaint for the right holder, and they just keep walking. In a West European country, it seems that internet piracy has become no longer prosecuted by the authorities, and that government, in fact, seems to be moving in a number of wrong directions with regard to online enforcement. And I haven't even gotten to China or Russia yet, which I think you all know about. All of these rob from the United States. They rob from authors and publishers both revenue and jobs. They rob from the U.S. government, both the federal government and state and local governments, tax revenue. And they rob from American consumers, who in the end up paying higher taxes and, I suspect, higher prices for those copyrighted goods to offset the losses from piracy abroad. So with that backdrop, it was decided that a global problem needs a global solution. And a group of like-minded countries who believe together and recognize that the importance of copyright and trademark to society and to their citizenry decided to negotiate an agreement that would become, we hope, a multilateral gold standard of modern best practices for the enforcement of those rights. In that context, the United States, ACTA negotiators, have made clear repeatedly their intent to conclude an agreement that is entirely consistent with U.S. law. I'm glad that the text has now been made public, confirming what we've said all along, and demonstrating that all the wild rumors that we saw on the internet are in fact false. Given this, I look forward to this morning's discussion, and I invite all of you, both here in the room and on the web, to consider, as you listen to the remarks of those on the panel who I'll characterize as ACTA skeptics, whether their objections are unique to ACTA or whether they are in fact objections to the underlying U.S. law on which ACTA is based. Thanks.
Thanks. Do any of the other panelists want to respond to that before we move on?
Sure, and I'm Michael Petricone again, just so you know where I'm coming from on this. The Consumer Electronics Association is an association that represents the technology industry. Basically, we represent the makers of all the stuff you see when you walk into Best Buy. And we also put on an event every January in Las Vegas called the International Consumer Electronics Show, which I invite all of you to come to. It's this Technopalooza, and it's fantastic, and I think you'd love it.
Yeah, and he has an iPad there that you can't see, and he didn't hold
yes,
out, right?
I'm with the Consumer Electronics Association. We're in kind of a weird position on this one for a couple of reasons. Number one, free trade is very important to us. It's one of our top policy priorities. It's critical for our companies to thrive. So we're big backers of free trade. We're an IP industry. We invent stuff. That's what we do. We depend on intellectual property. And we are greatly harmed by counterfeit goods. And despite all of that, unfortunately, we cannot support the ACTA text as it currently stands. We've got a number of things that give us severe reservations. We see the text as exporting the rigorous penalties in the U.S. law, the rigorous copyright penalties, without exporting the exceptions upon which our companies depend. It takes very controversial and rapidly changing areas of the law and basically locks them in and ties Congress's hands so they can't go forward and change them in the future. I guess more importantly, it exacerbates a very disturbing trend that we see of foreign states imposing civil and criminal liability on U.S. companies and individual executives abroad. You've probably all heard about the Google situation in Italy, where criminal charges were brought against Google executives for not bringing down a video fast enough, something they had nothing to do with that somebody uploaded. And the current text of ACTA would exacerbate that. And we see that as all severely harming our company's competitiveness. So again, we are big free traders. We are a big IP industry, but we have significant issues with ACTA as it stands.
Well, because we're going to be moving on to the substance in a bit. First, I just wanted to talk about, so you'll be able to, you want to respond to that, though.
Just on process. I'm Eric Schwartz, and since we're beginning with caveats, I'll begin with the caveat that I, too, am here speaking only on my own behalf and not for any clients or certainly not for the U.S. government where I used to work. I want to thank Future of Music Coalition and the New America Foundation for inviting me. Having said that, I've not been involved in the ACTA negotiations per se. I was not one of the folks who got to see the text before it was publicly released on April 10, but just a little bit from my own experience about the historical background of treaties, especially for those in the audience and for those listening on the web or watching on the web. I was involved when I was at the U.S. Copyright Office in the TRIPS agreement negotiations, which took many years and which were finished. Although they went into force in 1996, they were done in May of 1991, in December 1991, excuse me. The two digital treaties were done in December of 1996. That said, it is fairly common among the international context for countries to decide that the existing treaties, as flexible as they can be, as technology neutral as they generally are, that they need refreshing or, in some cases, upgrading. I think that what happened in the case of ACTA, I can't speak for the process of what was and wasn't made public, but there's a sort of common practice for like-minded parties to get together and talk about best practices on enforcement, since a lot of the treaties were about setting the norms in law, but not necessarily about how to actually engage in enforcement. And for anyone who's been paying attention to what's been going on in the music industry the last 10 years, it's not necessarily about what the laws say, but about how you enforce the existing laws.
Can everyone use their microphones?
Yeah, and so that said, I think that what ACTA is about is like-minded countries. Nobody forces countries to negotiate anything, and countries get together and decide to share information. I should also say that having been part of negotiations, a U.S.-Soviet agreement, so I really date myself, a U.S.-Russia agreement, as well as multilaterals, that the sharing of information is often as important as the agreement itself, and especially in the case of trying to get good enforcement practices and standards in place and sharing best practices. And I think that's a lot of what is going on. Leaving aside a lot of the rhetoric about, first of all, the agreement at this point, for those of us who have just seen it in the last month, has a lot of bracketed text. So to talk about what the agreement will do is a little premature, since a lot of it either says shall or may in many places for what countries shall or may do, and there are a lot of options and a lot of provisions that are yet to be set into the agreement.
So first I'd like to go discuss the procedure a little bit. I'd like each panelist, other than Steve, to tell us when they first saw the text and first had the opportunity to meet with the government to explain their position and their concerns, and if they felt the procedure has been transparent. And Eric, since you just answered that you only just saw it, could you answer in respect to some of your clients? I mean, the industry clients that you represent, when did they first see it? So why don't we start with Rich?
Well, back in April, we're part of a coalition that's supporting ACTA, which includes artist and label groups, organizations like AFM and AFTRA on the artist side, the RIA and ourselves on the label side, the Motor Picture Association. It goes on and on. You can go to the website and see all the people. Neil Turkowitz from the RIAA briefed me. I needed some bullet points before we issued our press release in support of ACTA. So before seeing the document, he was willing to share with me a lot of the background that he had learned from the government before we made our decision. I didn't actually see the final document until May when it was released.
Michael?
Yeah, well, first of all, this has been, and I'm sure Steve can I'm sorry, and Steve can tell you what the rationale was behind this, but this process has been essentially a very secretive process in which many stakeholders did not have input for a very, very long time. I think somebody recently called it Gollum-like, and I'm not going to echo that, but that's the perception. We were allowed. I'm just transmitting. But those are the concerns that are out there. We were brought in to see it, to look at one of the drafts in the early part of this year. We're under NDA, and if I talk about what we saw in that draft, I'd go to Gitmo or whatnot. So just to clarify, all the comments I'm making are on the April 20 draft, which was released. We called, along with many stakeholders in the technology and consumer groups. We called for the draft to be released publicly so that stakeholders could have a look at what was being talked about and discussed. And then that was released on April 20th, which is good because it allows us again to see what was really in there and see what the facts are. I would hope that from here going forward, there would be some ongoing mechanism in which stakeholders could have input and shape the direction of this treaty or this agreement. Another thing that concerns us is that Congress doesn't have any oversight here. Like normally with a treaty, they look at it and they approve it and they may have hearings, there's public debate. And with ACTA, the way it's set up, because it's an agreement, not a treaty, the definitions are kind of fluid. But the result is that Congress doesn't look at it. And there is no formal approval process. And there is no opportunity through that formal approval process for stakeholder input. So we are very much urging that some kind of process be set up so that all the various companies, consumer groups, everybody's going to be impacted by this because the stakes here are huge, has an opportunity to express their views and have input on this thing.
Okay, and Malini, because I think you even filed a FOIA request to get this document,
yes.
so.
Yeah, I was hoping you would ask this question just because I think Knowledge Ecology International is in a unique position, having never been offered the text officially until it was released on the 20th of April. But given a little time, I'd just like to quickly trace KEI's push for transparency in ACTA, our engagement with the US government in this process, and factors that played a role in the disclosure of the text. So the plans to start negotiating ACTA were announced in October 2007. In early 2008, the US sought public comment, but very little information was available through the Federal Register notice or the fact sheet on the USTR website. In fact, KEI was able to inform its comments in that process only based on a leaked discussion paper that had only been circulated to lobbyists for some businesses. And ever since then, we've consistently advocated for increasing transparency. We were completely shut out of the process. While the negotiators did all they could to maintain the secrecy, information began to become available through a series of leaks. And we obtained the first leaked documents in January 2009, a whole year after the US had requested public comment and several months after the deliberations had ensued. We proceeded to file a FOIA request with USTR for actually the same 7 documents that we already had in our position and ironically had obtained through corporate lobbyists in Europe. And were denied that request on grounds of national security, which was a flagrant deviance from President Obama's commitment to openness and transparency in government. I can share that the press had a field day with that story. In fact, the number of hits on our website was so great that it was down for some time. And following that, we were really taken by surprise to discover that USTR had initiated a process of, just as the speaker before me referred the process of non-disclosure agreements to certain parties that were handpicked by USDR. So actually, we had to file another FOIA request to receive the names of the individuals who had received access to the text under the NDAs, and that list corresponds to 42 people, mostly well-connected lobbyists, including from multinational corporations and representing international interests in ACTA, as well as 10 members who were serving already part of the formal USDR advisory system. No academics were consulted, and only 2 civil society organizations were allowed to participated in the NDA process, whom, of course, were not allowed to discuss the text. So KEI pursued meetings on transparency with USDR and members of the US government on several occasions, along with other groups, and also as a member of the Transatlantic Consumer Dialogue, which is a group of over 80 US and Europe consumer groups. And at one point, we were in fact promised a complete review of the transparency policies at the USDR, and also at the request of USDR in July 2009, 8 NGOs presented a detailed account that included 21 specific recommendations, including the disclosure of documents in negotiations, public participation and NGO accreditation at meetings, public consultations, agency obligations to discuss negotiating objectives, and also to undertake impact assessment. I wanted to stress, because I just wanted to, I wanted to make the point that the process in ACTA is quite far removed from the regular process at institutions like WIPO or WTO, which are far more open, participatory, and democratic. And anyway, just skipping ahead, sorry.
Because we're running out of time, so I'm just going to quickly, but we'll come back to you. You can come back to that. But do you guys just have any response? Because I know you're in the government, so you don't, it doesn't, you see it when you see it, yeah.
You know, well, a couple things. Obviously, the text is now publicly available, and obviously not nearly in final form. I'll let the government speak about the transparency that it has or hasn't had, and both formal and informal. I will speak from experience to say, well, a couple things. Number one, when you're negotiating any agreement, I spend my days now as a transactional lawyer in music and film doing production and other things. You know, what is and isn't negotiated publicly and privately is not necessarily that different than in my past experience in the U.S. government in trade agreements. The other thing, of course, is that there are 37 countries, so it's not clear what countries did or didn't want transparency as part of the process up to this stage. I can't speak because I have no knowledge to that. I'm not sure any of us do. But the fact that some countries might want to make it available, or for that matter, some countries wanted to keep their initial deliberations private so they could be more candid, would just be part of normal transactional behavior, having negotiated, as you said in the introduction, somewhere in the neighborhood of 20 bilateral and multilateral agreements. I can say that this process doesn't strike me as being that different than what I did 15 or 20 years ago in the government. There's a lot of informal discussions that go on with stakeholders. There's a lot, especially with the Hill, on what you are and are not doing, and I just think that that's a part of the process.
Okay, I'd like to quickly, because we're going to come back to questions and comments, but I want to make sure we get to the substance a little bit. So to leave procedure and get to the substance, and then we can come back to questions about both procedure and substance. But as to the substance, could each panelist tell us what they hope ACTA will or won't do, and what they feel is the most important or the most concerning provision?
Well, I'm going to do my little introduction. I heard Michael's before, which I've heard before. We represent creators of music. People don't realize we have 238 label members. Many of them are artists in their own right that own their labels. People like Joan Jett in New York, Ani DeFranco in Buffalo, Slug from Atmosphere in Minneapolis, the Hansons in Tulsa, the Skaggs family in Nashville, Burning Spear. I can go on and on. probably between 30 and 40 of the labels we represent are creators. The rest of our members, in addition to those people, are people who invest in the creation of music. My favorite line today, I wrote it down, Steve, is for-profit crime, because that's the way we look at what's going on right now. Thank you for that. That's more eloquent than I could have done it. Our big concern is these people are coming in, and we're going to support any legislation, treaties, anything of any type that stops this crime. You know, it's not kids, if you talk to people doing research like NPD and people who are out there who are taking this. It is companies. It is people who are sending people to links to infringing sites like RapidShare, and there's a Google ad next to it. You know, people are making money off of this piracy. If we don't stop this, at the U.S. 5 years ago, these are the IFPI statistics, not my statistics, the U.S. was 35% of the world market, 34 to 35%. When the IFP just released their statistics for 2009, we were down to 27%. We're losing our place in society because the greatest level of piracy takes place right in this country, other than China and countries with less developed music markets, let me put it kindly at that. But we do have to slam the door and have a worldwide policy like ACTA, because we have to be able to encompass this piracy. So our hope is this will slam a lot of doors and not give people exits to go to.
Michael?
Yeah, you know, again, we are an IP industry, but I've got to say that if the philosophy, you know, as you just articulated it, is we will support any agreement that appears to go after piracy, regardless of its damaging and corollary impacts on other industries, other legitimate industries like ours. I got to say no. That's just not acceptable. You know, I think we need to get a handle on the piracy issue. We were, I think, taken by the recent GAO report, which called into serious question all the piracy numbers that have been thrown around in these surveys for so long. Basically, the GAO called them bogus. And I think, you know, but we've got to figure out, if the piracy issue is this big, the solution's got to be this big. If the piracy issue is that big, the solution's got to be that big. And the problem with ACTA as currently written, I think it's very well intended. But there are all kinds of corollary and negative impacts that are going to severely harm legitimate industries like ours. You know, essentially the most innovative and dynamic sector of the U.S. economy that employs millions and millions of Americans and is leading our way out of the recession. What we'd like to do is have USTR make ACTA do what it says, which is an anti-counterfeiting trade agreement focusing on counterfeit goods, particularly those which impact public health and safety, without attempting to bootstrap controversial issues such as unauthorized downloading. And I've also got to say that there were discussions of kind of back-channel, or a mention of back-channel negotiations going on. There was not a great deal of discussion with the technology industry. We were largely locked out of the process for a very long time. And many of our other countries in the EU have come out with significant concerns about this agreement and what's in it, and provisions that are sought to be imposed on other countries. And I also, if I could just go back to what Steve said, in your opening remarks you said, try to gauge if those who are skeptical about ACTA are upset with what's in ACTA or upset with the underlying U.S. law. We're upset with what's in ACTA because, again, what we see in ACTA, in the U.S., copyright law is a balance of rights and exceptions. You've got the right to have monopoly control over your property, but then you've also got fair use, and it's a tension that's a balance. In ACTA, what you see is all of the sanctions being exported, but none of the exceptions and none of the balance. And that's not U.S. law, that's ACTA. And those were choices that were made, and that's something we're quite concerned about.
Michael, can I just ask you a question before we move down the line, if I might? You made a pretty broad statement about damaging your businesses. So basically what you're saying, and I'd like a specific example, why paying for intellectual property to the creators, just like when I go into a Best Buy and I buy the products of your constituents, how are they being damaged if we're asking them to pay for intellectual property for use? And don't get me wrong, we have members who waive compensation at their discretion to go to certain sites for a limited duration with something at the end, promotion for what, and they have a business plan what that promotion is going to get them when they waive their rights. But you made a very broad statement. I'm sure it's an example of how your businesses are being damaged. If it's being required, they pay for intellectual property.
That's a red herring. That's not what the ACTA debate is all about. Nobody's saying everything should be for free. Nobody's saying people shouldn't pay. What we are
Well,
saying
you said
is
your businesses would be damaged.
our
For
business
example,
will be
how
damaged
it
by,
would be damaged.
by ACTA, a bunch of reasons. The ACTA has secondary liability provisions in it, which means that that those who provide services, including legitimate companies, that may be used for infringement could be held liable. This would be a huge change in global copyright law. Most countries don't have secondary liability provisions in their laws. There are no limiting principles like the Sony Betamax test or mandatory fair use exemptions, and that, for example, would significantly raise the liability of U.S. internet companies. Again, I've already raised the issue. Kind of our worst case scenario is what you saw in Italy recently, where somebody uploaded a video. And an Italian court decided that was a criminal act. And before you knew it, a number of Google executives in the U.S. were facing criminal charges in Italy for something they had nothing to do with. They just provided the service. And these kind of second liability provisions in ACTA will exacerbate that trend. That it's a terribly bad trend for U.S. companies doing business abroad. So it's not, nobody's saying people shouldn't pay for stuff. That's not the issue. But any treaty which exposes legitimate U.S. companies to huge new criminal and civil liabilities for doing things that are legal in the U.S. is simply not a very good policy for the U.S. government to follow.
Okay, real fast, and I'm sorry, Michael, but before I move on to Malini, I'm going to ask Steve to respond because I can't I mean, I'm being a neutral moderator, but I knew one fact situation from my research in my days with the U.S. government about various countries' secondary liability. So I'm going to throw it to Steve.
Yeah, I want to respond on a few of the substantive points because I think we've been taken off in a direction that doesn't reflect what's in the treaty. It actually reflects red herrings. Talk about exporting enforcement without exporting exceptions. Well, ACTA very clearly, from day one, has never been about changing the balance of the copyright law. It doesn't talk about rights. It doesn't talk about exceptions. The Berne Convention, the TRIPS Agreement, the White Book Internet Treaties, all those things do that. ACTA does not. ACTA is just saying whatever the infringement provisions and exceptions you have in your law are up to you, consistent with all those other treaties that we've all negotiated and agreed to. And you should have some minimum types of enforcement actions available so that the remedies for violating the rights that you've set up, subject, of course, to the exceptions and limitations you've set up in each of your respective countries, so that those enforcement measures have some meaning. Because in lots of places, let's face it, they don't. So to say that ACTA is exporting without exceptions is to ignore that it's also exporting without rights. It's not talking about rights or exceptions. In terms specifically of the secondary liability issue, this is another red herring. The Google case happened without ACTA. How is that possible? How could something bad happen without ACTA? Well, simply because ACTA doesn't mandate every jot and tittle of secondary liability. It sets forth the basic approach to it in the U.S. and proposes that as standards to follow elsewhere. Could countries go beyond that? Sure. Have countries gone beyond that already? Sure. Does ACTA require it? No. So this is exactly what I meant in my opening statement. This is something ACTA does not require. And in fact, many, if not most countries already have some principle of secondary liability, though in some country it's applied inconsistently or it's not as clear. We think that clarity of law is going to help everybody in the market, consumers, consumer electronics manufacturers, ISPs, copyright owners, everyone. So I think that when we talk about what's in ACTA, let's not talk about exacerbating trends. What does it mean to exacerbate a trend? ACTA either will require something or it won't. And nothing in ACTA will require Google executives to go to jail there will be provisions, I hope, because it's not done yet, that establish basic notions of secondary liability that are consistent with the basic notions we have in the U.S.
Okay, so
Yeah,
now,
I'm sorry, because Michael responded to somebody, because he made a comment. I read ACTA, and I'm not as versed as you are, but it seemed very clear to me it's not going to decide what constitutes infringement or a standard of IP protection. Each individual government will do that. Yeah, that's clear in ACTA. That's one of the clearest things right up in the front. We're an international business as well. Your constituents can choose to do business or not do business in countries, just like my constituents decide what countries they're going to do business in and whether they're going to have their music go there. So I don't think that's...
well, Malini, now I'll move on to you. So what do you hope ACTA will or will not do, and what provision do you view as the most important, or with KEI probably the most concerning?
With respect to KEI, and I think it's also the same concerns that many citizens around the world have with respect to ACTA, our main concerns are twofold. First is the lack of a credible and transparent process, and the second is, and this is following up on Michael's point, we have evidence that the proposed agreement poses threats to privacy, civil rights, freedom of expression, access to knowledge and information, and threatens innovation. So those are the main concerns with ACTA.
Can you be a little more specific?
Sure, and actually I would like to respond to something that you said about it being completely within U.S. law, and this is actually, so KEI has done an extensive analysis of the ACTA provisions on injunctions and damages and concluded that they are not consistent with U.S. law, and we have presented this several times to the U.S. government in meetings, as well as very recently at a meeting that you were at that was organized by the Transatlantic Consumer Dialogue.
And what did I say? Do you remember?
No, I don't remember.
I
but
said thank you very much, that's helpful. We're very genuine about our desire to keep this consistent with U.S. law, and I'm going to look at that very carefully. So
Okay.
thank you again.
Steve, if I could just ask a question. If your position is there's no there, and that the U.S. technology community is somehow like unreasonably hysterical about this, why the secrecy? Why the lack of input? Why not some kind of process going forward to let stakeholders like my members give input, and maybe some of the things we're concerned about is not intentional, just the way things are phrased. Why not a way to kind of on a going forward basis to iron these things out? There was a comment made, and again, we were thrilled when the text was finally released after we asked for it for a while, along with the civil society groups. And then we recently said something, or read something by one of the European ACTA negotiators saying, all right, and this is the last text that's going to be released. And my reaction was, that's too bad. I kind of thought we were getting someplace here in a process. But again, if all this stuff is nonsensical or misunderstanding, why not a process going forward to allow stakeholders to have input in some kind of like regular structured way?
Well, generally in terms of transparency, I'm limited as to what I can say because I wasn't involved in that. I'm a copyright lawyer. This is a U.S. Trade Representative Office initiative, and they're the ones who've been making the decisions. I will tell you, no one on this planet is happier than I am that this text has been publicly released so we can get past this issue. It's my understanding that the USTR is in the process of organizing some sort of formal public consultation process. I also know from firsthand experience that there has been an ongoing process of consultation dating back long before the text was released that included civil society groups, Consumer Electronics Association members, ISPs, copyright owners, trademark owners, pretty much any stakeholder I could imagine. And I've been in meetings with all these folks too. And I can tell you that the U.S. proposal in ACTA, some of those meetings occurred before that proposal was presented to the other ACTA countries in a formal way, and changes were made to it as a result of the comments. So the suggestion that this has been a closed process or that anyone has been excluded, I think is at best misleading. And the bottom line is we have the text out, we know what we're looking at, let's talk about it going forward rather than continue to carp about perceived slights from a year ago or what have you.
Well, I'm not carping, but again, just to give, are we going to talk about it like at panels and do this, or is there going to be some kind of structure where stakeholders can have their input?
Well, I don't know what the
I think
structure...
that's kind of necessary at this point, don't you think?
I'd be very happy to have that. I don't know what it's going to be because I'm not in charge of it. USTR is. What I can tell you is, I asked USTR when I was invited to come here, what do y'all think of that? And they said, great, go out there and stomp down some of these ridiculous rumors we keep hearing about.
So Eric,
So, yeah, I'd love to get past process and into substance on a few things. First, to address some of the red herrings. I mean, Article 1 of Point 1 of the text talks about that parties can't derogate from international obligations of their existing agreements. So all of the rights and all of the exceptions in all the existing agreements, TRIPS and the digital treaties, can't be undermined by this agreement, number one. Two, exactly what this agreement is what all agreements are. Countries come together and negotiate that which they want for their own national purposes. And I think that the purposes for which the countries are getting together is not that different than the interests of some of my clients in the ACTA agreement. Mainly, it's to provide the proper tools for rights holders, working with governments where needed, working with other interested parties like ISPs to develop tools for proper cooperation for effective enforcement. Because what was last agreed to in the last international agreements that were done in December of 1996 provided rights and exceptions, but not effective enforcement tools. And what's been learned in the last 14 years of the reality of enforcement are that you need cooperation with ISPs. You need, in some instances, proper, clear secondary liability, as our courts have said. One other red herring, certainly worth mentioning, and again to put into some historical context. Besides the notions of the end of the Republic with this agreement, you also hear the notions of American cultural imperialism. For those of you who are not students of U.S. copyright law, I've been doing this for 22 years. When I started, you were required to put a copyright notice on a work to secure protection. The U.S. was unique that way. About 10 or 12 years before I started practicing, you were required to register and renew works at the U.S. Copyright Office. The U.S. was unique that way. If there has been a movement in the United States to amend its law, it's to move towards the laws of France of about 150 years ago. So if anything, the U.S. has moved its copyright law in the direction of the rest of the world, not the other way around, and that is the current law of the United States. And what has been agreed to and what is part of our law is also a part of the process of the harmonizing of the law so that copyrighted materials can more readily be licensed and distributed across national lines, because copyright law is territorial. So both for the positive purposes of licensing, you need that harmonization, and in order to engage for the rights holders, for artists and others to be able to do that, you also need effective enforcement, which also crosses national borders, and that's what ACTA is about.
wait, can we just move on to questions now? Because it's, I have a lot of questions that I think are going, I had all the panelists email me questions that they wanted me to ask them, and the ones that they wanted me to ask other people. So it's going to get even more intense here. And also I want to invite the audience to join in, and our web audience too. So email in questions if you have them, raise your hand if you have them, and because we're running short in time, so I just want to move to some questions. Is that okay? Sure. Okay. First question will be for you, Steve, because talking about the background and what's been, you know, the history of U.S. copyright law and whether we're being culturally imperialist or whether we're absorbing other countries' laws. How does ACTA compare to the free trade agreements that the U.S. has adopted over the past decade?
ACTA is based on the free trade agreements we've adopted over the past decade. One of the things that USTR first said before we even had a text to share with other countries or with the public and stakeholders was that if you want to know what we're thinking about doing in ACTA, go look at the last FTA we negotiated, which happens to have been with South Korea. The difference, if any, is that ACTA is much more modest in its goals than our free trade agreement intellectual property chapters. We've tried to broaden the language. The free trade agreement texts are incredibly dense, incredibly specific, reflecting every single detail of U.S. copyright law, and a lot of countries frankly balk at that, and it's not what you customarily see in treaty language. We decided for ACTA it was far more appropriate to look to the enforcement provisions from our IP chapters in these FTAs and try and approach them in a much more general way to provide flexibility both for the future for our Congress and for other countries, so as to set the sort of gold standard of best practices that I described at the beginning.
Ms. Steve, I've got one question for you that's my own. It wasn't emailed to me. I was wondering in this negotiation if there's been consultation, if the negotiating countries have all consulted with their creators, or if there's been outreach to, and I'm not just talking about U.S. creators who are well represented, but I know with FMC I did some work interviewing indigenous artists in countries and asking them what they need. And they found, we've heard a lot of things kept reappearing. One, they need education. They don't know what rights they have. They also need legal assistance to enforce their rights in their contracts. They sign owners' contracts and find out that they've given away rights they didn't know they had. And also just to enforce their copyrights. We were one country here from artists, performers. People come and they record my music and they record my performance and then they sell it. They're making money. I'm not making any money. There should be a law about that. And our response is, there is, and your country has that law. They didn't know, and they don't have the resources to enforce their rights. They said, well, what can I do about it? We also talked to artists who have money that's being collected for them. They didn't even know about it. They had no idea how to get it. Were any of these issues discussed, and what the actual creator on the ground needs and what can help them in enforcement and education?
Well, I'm pretty limited as to what I can say about what other governments have done, because honestly I just don't know. It's up to them, of course. I can say that as far as I'm aware, the U.S. process has been open to everyone, and I think a lot of the issues you're describing are candidly probably not addressed specifically in the ACTA text. We're talking about the sorts of remedies that are available, the authorities of enforcement officials to take action. When you get into no less important but more private-based issues of, does the right holder know that they have rights? Do they know how to try and vindicate those rights? Those deal more with information and cooperation, and that's another part of ACTA as well, not in the specific you shall do XYZ part of it, but in the international cooperation and training and information sharing, as well as I'd like to think if there's an upside to some of the uproar we've heard over ACTA, maybe more people who have rights and who deserve to have those rights vindicated in one form or another, maybe gain some additional awareness if they hear about this process through one means or another.
I would just say also from experience, both in the public and private sector, that, and having traveled a lot and done a lot of work, especially in Eastern Europe and other places, local artists wanted copyright laws, especially at the end of the Cold War, for the very reason that they wanted to be able to protect their own rights. But in a lot of cases, the common refrain from those local artist groups, I'm talking authors and musicians and others, was we actually are going to need the help of the Europeans or the Americans or others who have trade interests with our government to try to secure better protection and enforcement, because we can't get the attention of our own governments, frankly, because they've never had a working class of artists in the country. Everything had been owned by the state, under a socialist copyright system or something of that nature. And one thing you can be certain of, however, when you look at piracy rates in other countries, if American rights holders complain about piracy rates like in Russia of 90%, the local artists can tell you it's even higher than that, because if there's a local demand for it, it's going to be for the local artists, and so their material is going to be even more pirated than the American or European or other foreign artists, and so they absolutely do want better enforcement of rights and better licensing mechanisms, which I think ACTA will bring.
Well, I mean, that's what I was actually asking about, because these were artists who needed help enforcing their rights, and I was wondering if that's come up, because I just perused the text, I didn't get in depth into it, but I found an education for the public provision. Didn't see an education for artists. Saw certain cross-border cooperations, but nothing to enable artists to get their money. Or I saw kind of enforcement, without the rights holder on the customs agent on the border, without the rights holders filing a formal complaint. But I didn't see something saying, hey, and like you got to help the local artists too. When somebody infringes their work or records it and sells it. So I was just wondering, because those are all enforcement that we've heard artists on the ground need.
And in the case of criminal penalties, I mean, speaking from experience in Russia, the individual who tried to set up the first music collecting society there after being threatened by the local organized crime syndicate was killed. So that's the type of enforcement we're talking about. Rights holders can't bring civil action against organized crime syndicates. You need the engagement of the local government, and you need criminal enforcement activity. And those are the types of things, those are the types of penalties. They're not draconian penalties. They're penalties going after the for-profit crime, as Steve mentioned, syndicates and others that are needed. Yes, there are requirements under Article 61 of the TRIPS agreement, but they've either not been enacted at all in some countries, or in the case of Russia, there's an Article 146 that was enacted 9 years ago. Not a single person who runs a plant operating system has ever been convicted under that law. So then you need the next step, which is to actually use it and to get countries to be engaged in good cooperation for good enforcement.
Okay, does anybody out in either our web audience or our live audience have a question?
Well, those are two different questions.
Okay, I'll repeat it again.
Go ahead. Okay.
Given how little information about ACTA has made it out to the public, there's some that's made limited amounts that have made it out to people with law degrees and who practice. How would you panelists advise people to get ahead of it and get within the law of ACTA?
Number one, I'm not a lawyer. I think everyone else on this panel is. So let me tell you that I just go, and I have looked at the agreement and had assistance, but the U.S. Trade Office, USTR, has put out abstracts about a number of these things. So if you went to their website, you would see a lot of the points, and they give a pro and con. They raise a number of issues. I don't believe it's slanted in any way. My colleagues to my left may disagree.
And that's the thing, is you can find an organization who feels the same way you do. And, Rich, A2IM has a lot of things and hyperlinks on their website. KEI has a lot of things about this on their website. So you find the organization that kind of feels the same way you do and follow their positions. If you're talking about staying within the law, not violating the law, if you're American, I don't think you have to worry about it, because as Steve said, it's going to be consistent with American law.
Well, it's not an agreement yet. We certainly would like it to be consistent with American law. We're not convinced that's happening, which is one of our concerns. I would suggest another website. A fellow named Michael Geist, who is a professor in Canada, Geist, has a website which follows this quite closely. That's worth looking at. I would also, I guess my spin on your question would be, this isn't a law yet. Clearly, from what I've heard on this panel, hopefully it'll turn out okay, but people have raised some interesting thoughts and there are concerns. How do I make sure this turns out in a way that's good for copyright holders and good for the technology industry and good for consumers? And what I would say is, talk to your elected representative and press them to ensure there is some kind of forum and some kind of process to make sure that stakeholder concerns, including consumer concerns like yours, are taken into account and factored in. Again, I keep hearing from Steve, this process has been totally open, and that's just not that's like, as a factual matter, that's simply not true. And again, maybe there were perfectly legitimate reasons for not making it open, but it hasn't been open. And what we are saying is, given the level of concern on this thing, it should be open. I keep on hearing, well, these are just countries getting together to do what they think is in their best interest. This agreement was rejected by the European Parliament by 663 to 13. So clearly, it's not just a bunch of fringy tech people or fringy civil society people. There are very legitimate players who have deep and substantial concerns about the way this is going.
Okay, Malini, I'll ask you.
If you want to see both, in addition to Michael Geist, and I've looked at his, also look at Chris Castle's website, and he may give a different perspective on this issue.
Okay,
So you can see two
I would
different
add
perspectives.
Barry Sookman's as well. If you're reading the Geist on, as Canadians go, Sookman is an expert on Canadian law, worth reading Barry's as well.
So now I'm going to move on and ask you a couple questions, Malini. First, I'm going to ask you about process, because KEI filing the two FOIA requests probably was the civil society that raised the most issues about a non-transparent process. So what would you like to see going forward, not talking about the past, but going forward? And that's the process question. And then there is one substance question I would want to ask you, which is, could anything be done to change the ACTA text as you've seen it now to make it acceptable to the consumers?
Okay. Just in the interest of time, I'm going to just stick to a few points. In terms of the process, just also taking advantage of the fact that you're here, Steve, I think we would like to see the U.S. share its negotiating position with us ahead of the Swiss round, and follow again, echoing what Michael has been saying. We don't think ACTA is acceptable in its current form. We would like to see continuous consultations with consumer groups, with civil rights organizations, with educators, a wide range of stakeholders in this process, and consumers. And we would also like to have a continuing, we continue to have the expectation that the text will be released, and we will have access to the text even after the Swiss round. But in addition to that, we would like the United States to take the lead in advocating to expand that transparency by recommending to the other negotiating partners that the country negotiating positions are also disclosed to remedy the lack of historic record of the negotiations. We also seek assurances that the U.S. will not undermine citizens' privacy, civil rights, human rights, freedom of expression, and access to medicines. And lastly, we want the U.S. to remedy the imbalance by inserting public interest safeguards and missing exceptions that should go hand in hand with the high IP enforcement norms that are being pursued.
I have good news for you. The press release that all active negotiating countries released after the last round said, and I'll read it so there's no question, ACTA will not interfere with the signatory's ability to respect its citizens' fundamental rights and liberties, and will be consistent with the World Trade Organization Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, and will respect the Declaration on TRIPS and Public Health. There's no proposal to oblige ACTA participants to require board authorities to search travelers' baggage or their personal electronic devices for infringing materials. No participant is proposing to require governments to mandate a graduated response or three strikes approach to copyright infringement on the internet. I'm sorry that that wasn't good enough for you a month ago, but I hope you feel better about it now.
No, I think that's very encouraging, and we were very encouraged by that statement. I think we would be even happier if we could actually see that inserted in the text in the relevant sections. So not just a press release,
what does it mean to insert a section that says nothing here violates civil rights?
For instance, I have a proposal that there could possibly be a consumer bill of rights section that actually has principles that would assure these consumer protections and safeguards, and including references to the Doha Declaration on Trips and Public Health, including
We're getting really
other
wonky, guys.
including other such references.
I'm happy
where
to see
relevant.
that. Let me suggest that rather than talking in the negative, usually when you draft treaties and laws, you speak in the positive. What is obligated to be done under a treaty? What in the law is against the law? So if there's something in ACTA that you think violates any of these principles, please point it out to me specifically, because frankly, I think some of these are fairly wild. And if there's something you can point to and demonstrate that, yeah, there's a real problem here, we're happy to take a look at it and happy to fix it.
I will follow up on that, on a specific point regarding access to medicines. And this is an analysis that is not just KEIs, but a lot of public health groups. So it's the whole global public health community, including groups like Oxfam, MSF, Health Action International, and all these groups share the concern regarding access to medicines, especially in light of the fact that ACTA provisions seem to be promoting or seem to retain the kind of border measures or the kind of measures that have led to seizures of legitimate generic drugs that were in transit. I'm sure you've heard of the...
In addition, ACTA will not address the cross-border transit of legitimate generic medicines. This is on USTR's website. You might want to take a look.
We've seen it.
But it doesn't appear to have sunk in.
We're...
So, and that's an important thing to be aware of. We all look at it in the music community's perspective, but this is a broad IP treaty that will affect things like access to medicines.
Well, and if I could do that, I just kind of come into Malini's defense a little bit. You know, rather than sitting on panels and accusing other people of not having read the press release you put out last week or whatever, if there was some kind of ongoing process that allowed civil society groups like Malini's and Knowledge Economy to have input into the process, like there should have been set up years ago, then maybe we wouldn't be here having these discussions. But you can't have a secret process, and again, and that is what it has been, and there may have been legitimate reasons for that, but that's what it has been. And then, you know, kind of come down on people for not having shaped it the way they want to shape it. You know, there needs to be a way to gather these inputs going forward. I mean, again, you know, after the European Parliament rejected this thing by 600 to 13 or whatever,
which is not an accurate characterization.
I would hope, speaking of things sinking in, I would hope it would sink in on the negotiators that there are serious problems and serious issues here that have got to be addressed for this thing to go forward.
Well, the European Parliament didn't reject the agreement. The agreement isn't completed yet, and the European Commission is still at the table negotiating.
What did they reject?
They didn't reject anything.
What did they vote not to do by 600 to 13? Like, what did they vote on?
It was a referendum expressing concerns, and that's fine. They were giving instruction to their negotiators in the European Commission. That's how governments work, and that's fine. I'm fully in favor of more consultations. We had consultations. They've been open to everyone. No one has been shut out. No one's been told, oh, you're with that group? No, I'm not going to talk to you.
They had to file FOIAs to even see it.
No, that's not true. That's also not true.
Okay.
But here, let me make another point. We're here. I'm getting generic statements about, oh, lots of groups say I have concerns about access to medicine. Here's the agreement. It's been released for a month. What in this agreement? Show me the words that you want changed because you think there's a problem with access to medicines. And we can have a specific conversation. You've got an opportunity to have substantive input with an ACTA negotiator. We'll have more. I'm sure we will. But don't waste this opportunity. Let's go.
We filed extensive comments. And we'd like to know what the next step is.
I know. And some of those were entertaining too, because what you said here is you don't want to tie Congress's hands. But in the comments that I got from CEA and some other organizations just a few weeks ago, you complained that the ACTA text doesn't reflect the second sentence of the third subparagraph of the second subsection of Section 504 of the Copyright Act. So,
well, you said you wanted specific comments. We gave it.
Do you want to not tie Congress's hands, or do you want specific guarantees? Which is it?
It seems to me that on the one hand, you're saying I need specific. You know, this is all a misunderstanding. We need specific suggestions. On the other hand, you don't seem to be taking anybody's suggestions very seriously.
That's not at all true. That's not at all true.
Okay, let's move on to another question.
No,
'cause
I want to
gotta-
respond to that because that's very unfair. We've made many changes to the text in response to concerns that have been articulated. Show me where in the text it's a problem. Now this, what I just quoted about the second sentence of the third subparagraph, et cetera, goes not to whether or not ACTA is inconsistent with U.S. law. In fact, this paper specifically concludes that the U.S. would comply with the